law, immunities, law of the sea, and environmental law, and so on and so forth. Examples of such sanctions, just from the EU sanctions regime, could be the sanctions against Iran, the DPRK, Venezuela, Afghanistan, Belarus, and of course, the sanctions against China by the United States. A third category of sanctions, which is even broader perhaps and a bit more problematic, are sanctions in response to circumstances that present some kind of imminent danger or threat to the essential state interests. These do not necessarily fall within the previous two categories. This is, of course, up for debate, but I would perhaps categorize sanctions in the exercise of preemptive self-defense, or in response to cyber threats, or more broadly in response to harmful practices in the environmental or financial sector. This could be conceptualized under this category. Of course, further distinctions can also be drawn between different sanctions on the basis of the kind of measures that we impose. We have financial sanctions, we have trade sanctions. They consist of restrictions on import and exports of goods or services, traffic in transit, restrictions in banking transactions that we will discuss today. And of course, on the basis of the target, it can be the state itself, or it can be specific key individuals that are targeted through asset freezes, for example. So whilst all of the above fall under the general category of sanctions, it is evident that different types of sanctions pose different types of legal questions and legal challenges, and we hope that we are going to address some of these challenges separately through our contributions today.
Wonderful, thank you very much. So that sort of sets a lot on the table for us, and I want to go to Regis next, because I think that Regis sent in the project that he's working on. Sort of takes the perspective of the non-sanctioning states. As we know, there are many states that have joined the United States, Europe, and the UK in sanctioning Russia, but there are many that have not, and that have attempted to remain neutral. Regis, in the paper he sent in, uses a phrase that maybe deliberately was meant to evoke W.E.B. Du Bois of being caught between the devil and the deep blue sea, and the position of the third world in trying to decide how to manage this this new reality, or is it a new reality? And that's the question I want to ask you, Regis, to start with. Is what we're seeing new? Is it 2.0, or is this a continuation of sanctions 1.0 and a continuation of the old way of doing business? So, to you.
Thank you, Ben. And good morning and good afternoon to everyone. Good afternoon here. Well, I would have loved to be with you, and I thank the organizers for providing me the platform to express myself today, even though I'm not there present physically. Well, as you said, I used to ask whether are we in the phase of 2.0, or is it a continuation of past policy? My paper actually addresses that. The aim is to trace the sanctions regime of the United States vis-à-vis Russia through Cold War up to now. Because again, what I'm arguing is that the past policy have evolved, they have changed names, but they remain pretty much the same. So my first argument is that, well, it's the first position, what exactly is sanctions, the category of sanction, where it falls. Well, first of all, the sanctions are part of the tools that are used for economic statecraft. And economic statecraft, as you probably know, is the use of economic means to pursue foreign policy priorities. And the tools that are used, again, are lending, as Anna just mentioned, foreign assistance, trade agreements, and of course, sanctions. And sanctions are the tools that are used to remove, or at least to eschew, or to prevent benefit that a state party or a member of a trade agreements can benefit from, is to actually to provide that state can no longer benefit from these, from whatever it should benefit from, if it were, but not for the sanction. So the trade agreements are the tools by excellence to, or at least sanctions are the tools by excellence for trade, for economic statecraft. So what I'm saying is that, or what the paper actually says, is that today's sanction is a reflection of Cold War policy that actually never left. So I'm arguing that the United States Cold War policy actually have remained, they have changed, they have adapted to changing circumstances of global affairs, but yet they have used different rationales, different reasons to impose the same economic policy. So basically, what I'm actually saying is that today's sanctions are the reflection of past policy, and I will illustrate with one of the first trade sanctions that the US imposed, or vis-a-vis Russia, or the Soviet Union, as it was then called. So we can recall here that the evolution of the US trade policy vis-a-vis Russia or Soviet Union, today's Russia, has been on the same, I would say, has responded to the same type of actions. First of all, in 1975, the then president of the United States passed the law. He signed the law that was called the Jackson-Vanik Amendment, which was an amendment to the Trade Act of 1974. So the law actually was requiring non-market economy countries to comply with specific free immigration criteria as a condition or prerequisite for receiving economic benefits in trade relations with the United States. So what the Jackson-Vanik Amendment Act was actually providing for was to remove benefits such as the MFN, which is now called normal trade relations in US trade policy, and to remove or to prevent access to United States government financial facilities to businesses from Russia, from Soviet Union. So this was the act in 1975, which actually is a reflection of what we are actually seeing today. Basically, the rationale behind the Jackson-Vanik Act was a response to what Soviet Union has imposed back then. It was a diploma tax. What was the diploma tax? Well, it was a tax which was imposed on every Jewish citizen which was educated in the Soviet Union and wanted to leave the country. And the rationale was then the rationale for imposing this tax was to prevent brain drain. It was the argument that Russia was given back then. So it was making it more expensive for every Soviet educated person to leave the country. So as a response to this, the United States thought that, this was a restriction on free movement or violation of human rights. So basically, the rationale to impose that Jackson-Vanik Act was to prevent, or was as a result of a leakage of human rights with trade benefits. So basically, we always see that the same rationale even persists even today when you see the actions that have been taken by the United States vis-a-vis Russia as a result of the Ukraine invasion. So, and the context of the Jackson-Vanik Amendment Act was the conclusion 2 years earlier, or in 1972, of a trade agreement between the Soviet Union and the United States. So, basically, the Jackson-Vanik Amendment Act was actually saying that every benefit, MFN benefit, which was concluded within that agreement, would be suspended unless Russia decides, or the Soviet Union, as it was then called, decides to remove immigration, that immigration law. So if they deny their citizens the right to immigrate, or if they impose more than a nominal tax on immigration, on exit visas. So this was the rationale behind that. So now the question now, which I now ask myself is, or what the paper asks now is, since the end of the Cold War and the opening of trade between the United States and Russia, and even accession of Russia to the World Trade Organization, is there still a legitimacy to continue with this past policy? Well, or the story that, or history tells us that this is the case. It's a subject to debate, but still, we see that practice tells us that these policies remain the same. And this is what happened, or at least 1 year ago, in 2022, when the United States President, Joe Biden, signed into law an act which actually suspend normal trade relations with Russia and Belarus. Well, the purpose, or at least the rationale behind that, is to seek to link that trade benefits to human rights violations, which Russia is being accused of violating, and to make sure that, and the law actually provides for the removal or suspension of that restrictions, or to lifting of the restriction if Russia decides to remove or to seize hostilities and to recognize that Ukraine is an independent and free democratic society. Basically, this goes down to say, to conclude the first part of my initial talk, to say that from 1925 with the Jackson-Vanik Act and 2002 with the Joe Biden law, we just suspend normal trade relationship between United States and the Soviet Union, that things have not changed that much, in the sense that the same policy that applied back then still applies today. And to respond to the same imperative of statecraft, which is that of using economic tools to pursue foreign policies.
Great, thank you so much. So that allows us to pivot to some more technical problems, I think, because now we have this sense that something new is happening, but maybe something old is happening. And I think Niall and Diana, I think your paper also gets at this, right? Because you point to an old problem that is becoming newly acute, maybe. Because one problem with sanctions in the global economy is that the economy is fundamentally integrated, and markets do not ordinarily care about a difference between oil from country A or country B, unless the oil itself is different, or between widgets made in America or one made in Russia. And so maybe now, Diana, perhaps you can describe some of the problems that companies, private actors, but also officials face in administering sanctions when we're sanctioning Russian widgets, but not American widgets.
So thanks very much, Ben. So I'll start with some of the problems facing officials and move on to companies. So our paper looks at this in the context of sanctions against Russia. And it is a big problem where the EU stops exports going to Russia, but you then see a surge in exports going, passing through a third country, quadrupling. And absent a credible alternative explanation, there appears to be a hole in the bucket. So our paper looks at rules that could respond to this. And I was looking at the export dimension, while Diana was looking at imports. So in addressing circumvention, a key question for officials is the extent to which they should enact tighter export controls at home, or whether they should engage with the third country directly. And one of the main areas of focus for the EU in its most recent sanctions package is on this area of circumvention and the role of third countries. So this package envisages restricting certain exports to third countries where there is a risk that goods will be moved on to Russia. However, the final product, it appears to be somewhat defanged by some procedural requirements that must be observed. So briefly, the EU must first notify the third country, track additional data breaches, and demonstrate that alternative measures have been ineffective before it can act. So even in a worst case scenario of an unfriendly third country deliberately passing on crucial material to war effort, there are quite a few steps there that have to be taken before acting. So it risks being somewhat futile. It is a cumbersome process, but of course it is a very delicate area politically. So there is the balancing act of wanting to penalize circumvention and not wanting to drive potentially non-aligned states closer to the target country. So it appears that the emphasis would be more on restricting goods leaving the EU in the first place, and I think that's probably the correct approach. So then for companies, there is a difficulty in terms of the level of due diligence that is expected of them. So Commission guidelines emphasize a risk-based approach calibrated to the activities of the business, things like contractual clauses penalizing where goods are re-exported, ex-post verifications, etc. And our paper looks at how such rules could be formulated, trying to draw lessons from the arms trade inter alia. And some of the things we recommend, including identifying goods that are flowing and prioritizing those that are crucial to the war effort, difficult to source, and where the EU can make an impact in preventing their being obtained. And the more of these criteria that are met, the greater the emphasis that needs to be placed on these goods. So for certain goods critical to the war effort, it's not enough if a fine is dished out a couple of years later. And if that's accepted, then the emphasis should be on pre-shipment control measures. So we recommend that in certain instances, only licensed exporters should operate and should only be granted to low-risk operators. So in certain instances, we recommended watch lists being put in place, and indeed very recently, the EU published a list of high priority battlefield items on June 23rd. And this covers 38 HS codes, things like electronic circuits, etc. And it said that this is there to support due diligence. So due diligence is expected of exporters, and more demanding and concrete measures are being put in place. So Diana's going to talk about the import elements.
So for the imports, we're talking about goods coming into the European Union. That was our focus. And basically for officials in the European Union, each country is responsible for the customs. So we're having, every country must assess when a good comes into their particular country, whether the paperwork is accurate, whether the paperwork accurately describes the origin of that product. And we've found in our paper, in our research, that there are instances of falsification or perhaps inaccurate descriptions of where these goods originate. So goods that originate in Russia are coming into the European Union based on a different origin. So an origin that results from a non-sanctioned country. And so the custom officials in each country are challenged. They have to face this challenge of understanding where this good comes from. And then for companies, exactly, if you're in a global market, you need to understand where each of your inputs come from. So you need to trace back down the production line where your various parts are originating from. And it just needs to be to present to you all that simple assembly does not confer origin on a product. So if you have goods inputs coming out of Russia and going into a third country and are simply put together, that doesn't give origin, that third party country origin to that good. If the parts are simply put together, it's still a Russian good. And so under the European non-preferential rules of origin and many preferential trade agreements, simple assembly does not confer origin. So with regards to customs officials, they need to understand, was there enough processing done in that third country for it really to have that country's origin? And certainly for companies as well, they need to understand where my inputs are coming from. And if the inputs were put together in a third country, was there enough processing done to result in that good having third country origin so that I can then bring the good into the European Union? And I'll go into a little bit more details about the European Union aspect, I think, in the next one.
Yeah, great, that's perfect. So yeah, that's a good setup. But at this point, we've been talking about sanctions as if they're affecting physical, almost tangible things, right? Like widgets or barrels of oil. And as Anna pointed out at the beginning, we can talk about those kinds of things as trade sanctions, but we're also living in a world of financial sanctions, which Armin, your paper focuses specifically on, and which you've argued are new or at least newly widespread. And so what are financial sanctions and why do they pose particular problems now?
Thank you, Ben, and thank you everybody for showing up this morning, despite the disruptive sleep that some of you might have suffered, especially those who have arrived only recently, like myself. I would like to highlight 5 characteristics of financial sanctions that distinguish financial sanctions from standard trade sanctions. The first is that we are not talking about sanctions and trade and goods, but about transfers of capital. Yeah, transactional sanctions want to aim at inhibiting transfer of capital. That means that the flow of funds from or to the target country should be curtailed. And the implication of this is that sanctions do not deprive only specific goods or specific sectors of an economy, but rather the entire economy broadly. Right, so it means that your financial sanctions may even affect exchange rates, it may affect inflation, and it may affect, above all, a government's ability to finance itself, because it wants to deprive governments from access to capital markets. This is a first very important feature that we want. It aims at limiting sovereigns from having access to capital markets. Second feature, we are moving from a state-centric to a market-centric enforcement of sanctions. Because the whole idea of financial sanctions is to weaponize the existing financial and capital market infrastructure, right? So the idea is to make sure that intermediaries, financial intermediaries, enforce sanctions vis-a-vis the target country, for example, by prohibiting financial intermediaries to transact with the country. And given the infrastructure that exists, it can be extremely powerful. And just to give you a couple of examples, SWIFT is the classical example. SWIFT is a financial messaging service that accompanies every trade or every payment correlated to trade, and it covers 80% of all financial transactions. And if you curtail or prevent a company, a bank, or an entire country to have access to SWIFT, which is a Belgian registered private company subject to the orders, public orders, then you deprive the sovereign from practically from transferring funds. Second example, Euroclear or Clearstream, rarely known but very important financial intermediaries who sit between a sovereign who issues bonds and the bondholders. And so if you ask these intermediaries not to transact anymore in relation to the sovereign, for example, not to pass on the coupon payments that a sovereign pays to the bondholders, so you practically cut off the country, the sovereign, from the capital market. And finally, these companies, again, Luxembourg and Belgian-based companies, run huge profits and excess money at the moment because they're accumulating all these coupon payments that they do not pass on to Russia. And other examples are just prohibiting banks to give loans to countries, as the US did with Venezuela 2017, or earlier already British banks being prohibited to give loans to Argentina in the 80s. Third, very shortly, important feature is we're talking about an empirically growing exercise or practice, right? So Russia is subject to 100 different financial sanctions, but the Russian case is only the last mosaic in a trend. In 2010, the IMF observed that 25 countries were subject to financial sanctions, and 10 years later, in 2022, 12 years later, it were already 60 countries. So we're talking about something that is gaining empirically relevance. Fourth feature, financial sanctions are almost always unilateral in nature. And the unilateral character is basically due to the fact that financial sanctions are a powerful instrument only in the hands of a few countries. Those countries who have a powerful currency and who can use their currency as a weapon. So it's an instrument that often refers to the exorbitant privilege that especially the US dollar has in being relevant for all kind of financial transaction. So it's a hierarchical, non-egalitarian, and especially non-reciprocal practice of sanction, right? Financial sanctions are rarely reciprocable if the US uses its currency powers. And this leads me to my final point, which I would like to emphasize, because it connects to an evolution from moving from territorial sovereignty to monetary sovereignty, meaning that financial sanctions increasingly discount the territorial nexus with the target country and emphasize what in the literature is discussed as monetary sovereignty. And by a very basic definition of monetary sovereignty means that a country is able to control its financial and monetary system. And with one country or few countries having currency power, you may weaken those countries who depend on this currency, especially when they issue foreign denominated debts dollar-based debts. So you introduce an immediate hierarchy of currency, and this leads to the observation that was initially made in this monetary sovereignty literature that you have a very detrimental effect to those countries who depend on this currency. However, I would contradict with another observation in that literature that is especially political economy driven, and this literature strand of monetary sovereignty observes that sovereigns are increasingly unable to control their monetary system because of transnational financial corporations who basically took over the control of monetary sovereignty, and given the ability of the mobility of capital, leaving sovereigns without tight control and a grip of their currency. However, this financial sanction for me, and so the conclusion of that literature strand is that the Westphalian order is declining, yeah, in terms of monetary sovereignty. But I think that the financial sanction is a powerful sign that this may be not true. That this is maybe not true because we see how strong those countries who have currency power can control and can require big companies, banks, financial intermediaries to comply with the sanctions. So we have a kind of public-private cooperation or public-private Westphalian order, if you wish. So this is what I observe, which doesn't really match this increasingly this literature strand. And I would leave it here with this first 5 observations.
Wonderful, thank you. And I think we can go here to Daniel, because once we're talking about financial sanctions, we're talking about banks and financial institutions as primary targets or primary players or primary intermediaries. And in the past few years, we've seen high-profile incidents of sanctions involving central banks, right? We can think about Afghanistan, Iran, Russia. All those examples are different in their own special way, but they're all involving central banks. And so, Daniel, why am I separating out central banks? Why are we talking about them separately? They're just banks.
Thank you very much, Ben. Thank you, everyone. My job today is made much easier by Armin, Anna, and my other co-panelists. So you will hear some things that will echo what has already been said. But I do believe that it is important to isolate specifically central banks for a couple of reasons that I'm going to mention in a second. Before going there, though, just to link to the idea of Sanction 2.0, I just want to set the scene. The idea of sanctioning central banks is not new. Central banks have been the subject of sanction in the past, notably the Central Bank of Iraq was one of the listed sanctioned by the UN Security Council regime in the early noughties. The Central Bank of Libya was also subject to UN sanctions in 2011. But what we are seeing today is a development of sanctioning central banks in 2 directions. The first one, again, to echo what Armin said, is a numerical increase of sanction packages that explicitly target central banks. And you mentioned Russia, Afghanistan, Iran, of course, has been under US sanction for many years. But we forget that Syria, for example, has been under EU also sanctions for a number of years, and also the Arab League at some point. And this also leads me to the second factor that I consider special about this new trend, which is the idea that, again, has been already said before, with the exception of the sanction against the Central Bank of Mali last year, which were imposed by the Economic Community of the West African States, all other sanctions against central banks taken in recent years are completely unilateral. So taken by individual states or group of states against, outside the framework of an international organization. And as we said, unilateral sanctions do pose problems in and of themselves, but I do believe that when it gets to central banks, there are 2 factors that make these sanctions particularly difficult to reconcile with international law. The first one has to do with the role that central banks play in the economy of a state. Now, obviously, they have an important macro level function. They control the monetary supply, regulate interest rates, they hold foreign exchange reserves, so they pursue price stability and inflation goals. They have also a micro level function. They act as lenders of last resort for other banks. They may have a regulatory function with regard to commercial banks. In some cases, they may even manage sovereign wealth funds. So they have a very important role And to me, the interesting aspect of sanctioning central banks is that these sanctions do not happen in spite of this important role, but exactly because of this role that central banks play in the economy of a state. And I'm just quoting the statement now by the issued by the UK government when issuing sanction against the Central Bank of Russia. The declared goal was to devastate Russia's economy and to cripple Russia's economic development in both the short and long term. These are not my words, these are the word of the UK government. So when I see these statements, I am brought to think, what about the idea of targeted sanctions? So as you may be familiar, the history of international sanctions is a move from comprehensive to smart sanctions, especially after the negative experience of the sanctions against Iraq in the 90s. What central bank sanctions are special or interesting to me is because they represent somehow a reversal of this trend. States sanction central banks because the goal is to curtail the economy of that state. And now, obviously, there are differences to use the criteria that Anna introduced. There might be sanctions, of course, taken in response to an act of war. But when sanctions are taken for other foreign policy objectives, we may actually think about can we reconcile these with principles of international law concerning how we sanction. And I'm not saying anything new. The UN Special Rapporteur on the negative impact of unilateral versus measures on the enjoyment of human rights has linked especially the US sanctions against central bank of Venezuela, for instance, with the deterioration of the humanitarian situation in Venezuela. And so this is one problem that I think we need to address if we are serious about sanctions. And the second aspect that I think is interesting very briefly about sanctions against central banks is that central banks are increasingly becoming the target of sanctions because they are quite enticing targets. Because of the way in which the international monetary order is built, as we described earlier, there are certain key banks that hold foreign exchange reserves for most other central banks. And we've seen that in the case of Russia, the G7 states freezing foreign exchange reserves resulted in an estimated $300 billion in frozen assets in foreign exchange reserve, which amounts to half of all the assets held by the Russian central banks. And when it comes to the assets of a central bank, the other big hurdle that I think we need to be able to address if we want to, again, be serious about sanctions, is the immunity aspect of these assets. Obviously, the very idea of a central bank is to distinguish it from the government of a state, to keep fiscal and monetary policy separate. But, and while there is some disagreement among states as to the extent to which assets of a central bank benefit from immunity, there is virtual universal agreement that assets that are used for central banking functions, so foreign exchange reserves as the epitome of that, are to be immune from measures of constraint. And so we need to be able to address this. And I guess we're going to get back later in the discussion as to the international legal aspects and the challenges that these can address.
To enlighten.
Wonderful. So, so those are all our problems, right? That's just enough to solve. We have 45 minutes left to solve them. And so we have a wide range of techniques, a wide range of practical problems and policy concerns. And now I sort of want to turn the prism to focus on international economic law and how can sanctions be done consistently with international law, if at all. You know, to focus on one part of international economic law first, one thing that we can be almost sure of is that sanctions are at least in tension with the rules of the World Trade Organization, right? Sanctions require us to discriminate among the WTO members based on the origin of goods, and the WTO generally requires non-discrimination, to be very basic and non-nuanced about the whole thing. And so Niall and Diana, one thing that comes out clearly in your work is that to enforce sanctions effectively, states might not only have to make distinctions between Russia and everyone else, but between a whole bunch of other states that are not sanctioned states, but pose special risks of sanctions evasion. And so can you talk a little bit more about those different kinds of distinctions that states might have to make?
Yeah, so in this bid to prevent circumvention, we looked at how rules on export restrictions could apply to 4 different types of countries where this could occur. So firstly, we looked at countries that are allied to the target country, countries that share customs union with the target country, the EA-EU in the context of Russia, countries where there has been a spike in exports since the sanctions have been enacted, and then fourthly, neighboring countries. So in relation to allied countries, these are obviously the highest level of risk, and we said that exports to these countries should be treated as though they were exports to the target country itself, and that this is necessary to prevent the circumvention of sanctions. Secondly, in relation to neighbours, this has to be taken on a case-by-case basis, a bespoke approach applied based on the level of risk. So Russia has 14 neighbours, and Belarus is different to Norway, is different to Turkey and North Korea. So the risk profile might be based on various factors, geography, trade volume, etc. And for those with a high risk profile, the sanctioning country should engage with the local authorities and may have to decide the extent to which exports will be restricted. Likewise, for the 3rd and 4th categories, where there is a spike to a country, the UAE or any other country, we suggest monitoring the trade flows, seeing what represents the spike, and potentially restricting exports as well. Customs unions also represent an interesting case. So Kazakhstan gets a lot of attention there because it also shares a border with Russia. Belarus is the only other EA-EU country in that situation. So where there is a land border, assessing the extent to which it is porous, whether there's customs checks, and because obviously there is the difficulty of seeing whether or not the buyer of the goods in Kazakhstan will move these on to Russia. So the more of these that are ticked, the greater the scrutiny there will have to be. And the data certainly suggests that, and that's why we started writing this paper at the start of this year when we saw this data both for imports in and exports out of the Union. So ultimately, we said that cooperation with the authorities in these countries is the best outcome. And where this isn't achieved, restrictions should be accompanied by clear communication about what needs to be done for this to be removed. And this should be coupled with export restrictions and clear due diligence requirements for exporters.
So on the import side, we also look at these 4 categories that were mentioned, and you have kind of a similar issue is if there's a perceived spike of imports coming from some of these kind of targeted risky countries, you need to also investigate what's happening there. And recently in the 11th package, so the regulation that was issued on the 23rd of June, there is a provision that says you need that steel products or goods incorporating steel cannot be imported from 3rd countries if that steel or the steel products originates from Russia. And then there's another provision that says it's up to the importers to verify that their products doesn't contain Russian steel. But there's not really any explanation of how you're going to go about doing that. So that's when you can actually look at rules of origin, because they provide some of those tools to explain how and where this good comes from. But as we were explaining as Niall was explaining, there's the issue that these are products that are coming from rather risky countries. So we propose that you need to also increase the certification requirements that are already existing in these rules. So just to make it a little bit more harder, yes, but this helps verify that when you are importing or when a good is coming in from one of these countries that are in these 4 categories, you can be a little bit more sure that this is a good that was produced within the non-sanctioned country, or it's a good that is a steel product, for example, because some of the products that fall under this provision are various household items like forks, in addition to railway lines and tubing. But these products that have steel are not, they do not contain Russian steel. So in addition to looking at sort of the, let's say, administrative rules of origin, which we already have existing in our non-preferential rules of origin and our preferential rules of origin treaty agreements, we were also experimenting with adding additional substantive rules. So in some of these countries that are in these 4 categories, you would say, all right, let's add another requirement of processing. You need to do a little bit more work on this good for it to confer origin, non-sanctioned origin, or you need to add a little bit more local inputs or input sourced from another country, but not from a sanctioned country, in order for you to get this additional origin so it can come into the EU. Or you have to do a little bit more work, so there has to be a higher labor content. And so these an additional layer of substantive rules for rules of origin within these non-sanctioned countries just adds another check. It really makes you work. There has to be work, time, labor, and energy in the production of these goods, so that you understand these are really made in a non-sanctioned country, and they're not goods that are being rerouted from Russia into a non-sanctioned country into the EU. And of course, these would be temporary measures. They would be restricted to the time of the sanctions. And of course, they would be targeted to key goods and hopefully not too complex. So.
Wonderful, thank you. So Anna, we have sanctions that discriminate between sanctioned countries and non-sanctioned countries. And now we have maybe a need for rules and processes that discriminate among non-sanctioned countries based on the security risk that they propose. They pose. It's not much of a leap to think that this is going to violate one or more WTO obligation, prima facie. And so how, without using the exception word, well, let's go there. Let's talk about exceptions. How might we save these measures?
Yeah. Okay. So let's go down the rabbit hole of security exceptions. I know a lot of people in this room are already working on this subject, and I'm sure that most of you already have a strong opinion on their applicability and interpretation. Just as a first introductory remark, I get the sense that sometimes when we talk about economic sanctions, it is implied that there's some kind of law of economic sanctions which is separate to the rest of international law. In my mind, we can summarize the law of economic sanctions quite simply in one sentence: to the extent that an economic sanction is inconsistent with a state's international obligations, and it's not just a lawful but unfriendly act of retortion, it must be justified on the basis of an applicable defense. Otherwise, it results in international responsibility. So the main question that we need to be asking is what defenses are available to the state in each different dispute, depending on the circumstances and the sanctions in question. So in the case of the WTO, obviously, there is a tension between several trade sanctions in the WTO, if not all of them. And the question is, what defenses are available under the WTO? Obviously, the general and security exceptions under the WTO agreements are a way forward. The question here is twofold. First of all, do all the sanctions that we described and we discussed before fall under these exceptions? Are these exceptions sufficient to actually render all the sanctions legal? And if not, is it possible for a responding state to rely on top of these exceptions to other defenses under the law on state responsibility, for example, as enshrined in the Articles on State Responsibility in Part 1, Chapter 5. So I will try to summarize as quickly as possible my arguments, and hopefully we will have some more time at the end to discuss. So I will use the typology that I introduced at the beginning of this session. So with respect, firstly, to sanctions imposed in the context of armed conflict, of course, we know that under Article 21, states can take measures that they consider necessary for the protection of their essential security interests in time of war. This, in its ordinary meaning, and as it has been interpreted so far, means armed conflict, whether international or non-international, which means that this kind of sanctions can fall within the regulatory scope of this provision. My understanding is that the term war is also agnostic with respect to the legality of the use of force, which means that this security exception can be used even by the state that is actually responsible for the initiation of the armed conflict, because Article 21 is concerned with the protection of essential security interests, and these interests arise in the context of armed conflict, whether you have initiated it or not. So all this type of sanctions from both of these countries would fall within this definition based on this interpretation. The main question here is whether measures taken in the exercise of collective self-defense, so by third states, would also fall within the scope of the security exception. As it has been interpreted so far by panelists, it seems that measures taken in the exercise of collective self-defense would fall within this exception, because the term other emergency in international relations has been interpreted as encompassing any kind of emergency that leads to a breakdown or near breakdown of the international relations between states, near comparable to war. And this does not have to originate in the territory of the imposing state or involve the territory of that state, which means that a third state assisting the target of an armed attack, the victim of an armed attack, could adopt sanctions under the exceptions. Of course, the chapeau, which is essential, relating to essential security interests, and it considers necessary, as it has been interpreted so far, could add some additional considerations here. But first of all, the notion of collective security, which underlines the UN Charter, could be used here as a means of interpretation. And we could say that essential security interests are involved even in cases of collective self-defense. And secondly, at least so far, the test for it considers necessary for the protection of its essential security interests has been interpreted as a mere non-implausibility test, which means that the threshold is very low. So measures in the exercise of collective self-defense would fall under the security exceptions. Things are a little bit more problematic with the second types of sanctions that I discussed before, which are sanctions aiming at inducing compliance with international obligations. Sure, some of them will still fall under the security exceptions. That would be if the prior internationally wrongful act to which they respond relates to security concerns. For example, sanctions in relation to nuclear disarmament, counterterrorism. There is a strong security interest, so we could classify them under the security exceptions. But if we take, for example, sanctions in response to violations of human rights obligations in a state that is geographically very remote, it is very hard for someone to argue that this involves essential security interests, right? So we have seen some efforts to justify this kind of sanctions under Article 20 and specifically the public morals exception. I find this a little bit problematic. Christian has written an article that says that this is a moral stretch. Indeed, it is a stretch and it creates a number of problems. First of all, these kind of sanctions are designed to induce compliance. They are not designed to protect public morals. Secondly, there is a consideration here, which is my public morals are imposed on a third country, right? So for the protection of my public morals, I introduce a sanction which relates to a situation of violation of human rights in a third country. And all of this together lead up to the conclusion that perhaps this kind of measures would not meet the weighing and balancing test. So would they actually be necessary and proportionate under these circumstances? So I do not believe that it is actually appropriate to use the public morals exception in these cases. Also, there are some issues about also, for example, sanctions in relation to conservation of exhaustible natural resources, whether they could relate to that. Again, these kind of sanctions are not designed to protect exhaustible natural resources, right? They are designed to induce compliance. So, and I'm going to drop the bomb here and probably just discuss this later. I believe that for this kind of sanctions, the defense of countermeasures under general international law is residually applicable in WTO disputes. I believe that for this kind of countermeasure, for this kind of sanctions / countermeasures, WTO adjudicative bodies must be able to apply the countermeasures defense and apply the relevant requirements under general international law and not squeeze them into the security exceptions, which also have more lenient requirements. And I think that this is both analytically appropriate based on an interpretation of WTO agreements, and it is also practically desirable, because this is the only way in which we can both render this kind of sanctions legal, but also subject them to legal scrutiny under the customary requirements of countermeasures. I'll leave it to that, and then we can probably have some more time for discussion.
Wonderful. Yeah, I think that's very provocative, and hopefully we'll have time to discuss. But WTO law, I'm sorry to say to the WTO lawyers in the room, is not the only thing relevant here, right? So we have sanctions also implicate a range of other international legal doctrines, whether we're talking about the prohibition on intervention, whether we're talking about economic and social rights, whether we're talking about potentially the IMF Articles of Agreement, as Armin, you point out in your paper, or the law of state jurisdiction. And financial sanctions in particular are tricky to square with our categories for state jurisdiction. And so I'm wondering if, Armin, you can sort of carry us forward with that.
Yes, and I'm happy that I don't have to pick up the bomb that you dropped between you and me, because I'm turning to a different direction. Again, financial sanctions. I start where I left you with the observation that we are moving away from territorial sovereignty to monetary sovereignty, with a vanishing nexus between sanctions and territory, which raises obviously jurisdictional issues. And I want to argue that there's one country exerting excessive jurisdiction. You may guess which one. The second, not country, but international organization or supranational organization, the EU, tapping a middle ground, and then one international regime, international economic regime, which has rarely been mentioned so far in this conference, should have jurisdiction, could have jurisdiction, but doesn't exercise jurisdiction, the International Monetary Fund. Starting with the country exerting excessive jurisdiction, the US, I mean, it's obvious that if you have a US person involved or a transaction taking place on US territory, no problem. Problem occurs if there are secondary sanctions of foreign nature. If foreign transaction in a foreign country involving foreign companies, involving transaction between foreign banks are involved, and still the US claims jurisdiction. Why does it do so? Because if a dollar transaction is involved, technically a correspondent account, a dollar-based correspondent account based in the US must be established and must be used. Even if that is only peripherally the case. Really, only money going for logical second, if you wish so, through a correspondent account. And this is the connection point for the US to claim jurisdiction. So it's obviously not territorial principle. It's hardly to argue that it's effect doctrine, because there's not really an impact on the payment structure of the infrastructure of the United States. It is also difficult to argue that the protective principle jurisdiction, where allowing a country to secure and protect its essential interest, is concerned. However, this correspondent account jurisdiction established by US courts, very established line of jurisprudence by now, it developed in relation to Iran, not yet to Russia, but in relation to Iran, bases this correspondent account jurisdiction on a mix of effect doctrine and protective principle doctrine. And with regard to Iran, the argument was always Iran sponsoring terrorism, and therefore any transaction of whatever little connection to Iran should be sanctioned. Given the security dimension and discussion regarding Russia, I don't want to delve into this, but this is certainly would not withhold the US also to exert jurisdiction in this case. The European Union, traditionally an opponent to secondary sanctions, to extraterritorial sanctions, arguing that this interferes with independence, with sovereignty, having even established blocking statute and blocking regulation, and with regard to Iran. So the EU is not proactively adopting secondary sanctions, which leads to the observation that the US sanction approach is one that uses its currency, the currency power, the point that I've emphasized before, and using secondary sanctions, whereas the EU rather leverages the financial infrastructure and the financial intermediaries that I've mentioned before, right? SWIFT, Euroclear, and Clearstream, they are all Europe-based private companies subject to EU regulation, and the impact of using them I've mentioned. The EU is very active in asset freezing, and the EU, as we also learned, is very active in avoiding tax evasion. Sanction evasion. Not so much on tax evasion, but on sanction evasion for sure. And then my last point, there's the IMF. And we're talking about financial sanctions. We're talking about transfer of funds, of capital. And this is not something that should be dealt with in the WTO. This is something that should be dealt with in the IMF. And if you look at the IMF agreement, it could do so. The IMF agreement prohibits restrictions on payments and transfers for current international transactions. I leave aside the discussion what current is, the technical term, current transactions means. So it's only related to payments connected to a trade. But I mean, in general, transactions, capital transactions, restrictions on capital transactions are prohibited under the Articles of Agreement of the IMF, unless they serve a balance of payment problem, right? So the IMF rules could establish this, but clearly it would mean that the IMF gets very much politicized and bothered with this security issue. So 8 years after the Bretton Woods Agreement, the IMF Executive Board adopted decision number 144, which is somehow a political move to say, okay, if countries adopt financial restrictions or restrictions on financial transfers and capital movements, they have to notify to the IMF. Yeah, but which basically boils down to a non-objection procedure, meaning member states only have to notify it. There's no legality or not even a plausibility check exerted by the IMF. But my point is that when we talk about a suitable regime applicable to financial sanctions, it should be the IMF, and we should talk about whether we should change the rule. I know withdraw the decision. I mean, it's not more than that. You don't even have to change the Articles of Agreement. I mean, given that we are in the geopolitical dimension, that unfortunately this rift goes also through international organizations, yeah, IMF and World Bank, being, as General Yellen says, I mean, the organizations of the US and other international organizations, I'm thinking of FAO, so going into a different direction. I mean, it's not likely that the IMF will adopt a regime change that would punish the hegemon, the financial hegemon of financial sanctions. But I mean, from a legal perspective, from a sound legal perspective, I think the IMF should be the applicable legal regime.
Great, thank you. And I want to thank our panelists for sticking to our sort of lightning 5 minutes apiece. If we continue to do that, we will have time for questions. So Daniel, I want to turn to you. And again, we get to central banks, right? And we have the special problem of immunity and whether or not these asset freezes on central bank transactions violate that.
Thank you. So when it comes to asset freezing, there are essentially two schools of thought to reconcile financial sanctions with the rules of immunity. And one view relies on the language of the UN Convention on the Jurisdictional Immunities of States and their property. If you look at Article 18 and 19, they essentially prohibit measures of constraints, including attachment, arrest, execution against the property of a state when taken in connection with a proceeding before a court of another state. So there is a view that relies on this language by pointing to the fact that most sanctions, almost in all sanctions I'm familiar with, taken against central banks are normally taken by the executive. And so they do not benefit from this kind of immunity, which really is judicial protection against measure of constraints. I find this argument, I must confess, not particularly persuasive. And the reason is that there are multiple reasons. I won't go into detail in the limited time that I have, but essentially, one, I think that this interpretation places too much emphasis on the language of a convention that is not even enforced. And the preamble itself says that this is not the definitive rule on immunity. Customary international law may be broader. And in fact, arguably it is broader. Yeah, I don't really see a distinction between, in practice, a measure taken by the executive and one taken by the judiciary when it comes to limiting access to funds from a central bank perspective. One may even say that executive measures there should be high protection against measures that are not subject to judicial scrutiny. But even then, there is also some practice of, for example, the non-aligned movements, especially explicitly complaining against US measures taken in breach of the rules of immunity in this fashion. And I swear we did not synchronize this presentation in advance, but my argument is that there is a better framework and we should look at this through the prism of countermeasures. And the argument is actually quite simple. I believe that the rules of immunity, very much like most other rules of international law, can be temporarily suspended when it comes to inducing compliance with the obligation resulting from the commission of an internationally wrongful act. There is some debate in here, but I think that ultimately the advantage of using countermeasures is that they provide us with a legal framework that has some elements that we can use, for example, to test some of the effects of the measures against central banks that I mentioned earlier. I'm thinking especially the requirement of proportionality, which is a bit more typified in the rules of state responsibility. We can start thinking how would it be better to use proportionality to assess whether taking sanctions against the central bank may be compatible with international law or not. In the paper, I go a bit more into detail, but for the sake of time, I limit myself actually to these remarks with regard to the freezing of assets, because I want to spend a couple of minutes on what is the current state of the debate. Because as I mentioned, one way or another, we might be able to justify freezing assets of a central bank. But the current debate that you probably have seen within the EU, there is a conversation between the Council and Member States. There are legislative initiatives in Canada, the UK, the US. The move now is to study whether it is possible not only to freeze, but to confiscate these assets, so permanently moving them away from the Central Bank of Russia and use them to provide reparation to Ukraine. The problem of confiscation is that it is a permanent measure. Once the assets are removed, there is no turning back unless you have to provide internal compensation to Russia, which I think is the last thing sanctioning states these days would like to do. So for many, this is the final word. Countermeasures don't apply. There is the temporary element that is built in, the inducement factor is just not there. I am generally in agreement with this, but I want to point out that I think it's not necessarily the end of the conversation. When it comes to the implementation of the obligation to provide reparation for the commission of an international wrongful act, there may be situations, and I'm trying to be as general as possible, we can get into detail now, where reversing the measure may not be necessary. If you think about it, if the obligation is, for example, to provide compensation, a forcible transfer of assets realizes exactly the effects that the wrongdoing state should have implemented had it complied with international obligations. Now, we get into tricky territory here. One, because there is not a lot of practice. States don't do it. It's very risky, obviously, for the reason you can imagine, to forcibly transfer the assets of a state. The only example that I could find that fits this model is an attempt by the UK to enforce the judgment by the ICJ in the Corfuciano case against Albania. In the immediate aftermath, they announced that they will attempt to seize assets, Albanian assets in the UK. They couldn't find any, so that argument was mostly left at the principal level. But some of the literature of the time found that there were no feasible protests, mostly because the arguments seemed to be built in this idea of countermeasure reprisals, as they were known at the time. Obviously, I'm sure that we are all sensitive to the fact that currently the situation of Ukraine and Russia is very different, because we don't really have a judgment by international courts. So, the situation is much more precarious. But and that explains why states are so reluctant actually to move on to these confiscation measures. What I do want to say is that you mentioned Euroclear. There are some attempts now to try and go around this, but for example, thinking, okay, if we can't confiscate the assets, can we not confiscate the interest generated by these assets? For example, Euroclear, as you mentioned, has accumulated considerable amounts of interest generated by this coupon that were never redeemed. Can we not use those to provide reparations? I don't think there is a meaningful distinction between seizing the principal asset and the interest generated by the asset, which still belong to the Central Bank of Russia. So
yeah, but I mean, if you, sorry for interrupting, but I mean, it's temporary and reversible regarding the assets. I mean, if the proceeds of the investment, of the asset mentioned, goes to the EU or to Ukraine or whatever, but the assets are then going back to Russia.
But then that's an interesting point. What is the asset? So I think that the thin line that I don't really see a distinction with is between the interest and the principal. The interests are still part of the assets. I think you see that in international adjudication, when damages are awarded with interest, you would hardly see that the compensation exclusively is limited to the monetary amount that was owed at the time that the harmful act was committed. So just to say, I don't think it's a no-go, but I do think we need a better legal basis. And that's why I think thinking in terms of countermeasures may help us to at least use as a frame. And so I'm going to stop here, and I can see already there are questions.
Thank you. So Regis, last word to you. We've been talking a lot about technical problems. We've been talking about schisms between the US and the EU, between the sanctioned and the sanctioning. But what about the states that are attempting to navigate neutrality in this new, potentially old world order? How do they navigate between the devil and the deep blue sea? What lessons could be learned from your suggestion that there's a continuity here with the Cold War?
Yeah, thanks, Ben. I've been following the discussion so far, and I find the approach is very diverse and very enriching. Really, the second part of the paper, I seek to contrast the vigor that we discussed earlier between the US Cold War trade policy, which somehow has adapted to the changing nature of global affairs, with contrast that with the waning force of non-alignment that may be worth reviving, I would say, in the current situation. Well, I do start with a bit of history behind the non-alignment, and also why I'm doing this. I'm trying to bring this approach to my in this research. Well, as we would know, non-alignment, or at least I would start with decolonization, started or was happening at the same time with the Cold War, right? And we mentioned earlier that the Cold War trade policies are the ones that are being replicated nowadays. And this is why the context is very important. And decolonization had two main goals. First one was political independence, and the second one was the struggle for new international economic order. And as you will know that non-alignment movement was very important in trying to campaign for a fairer international economy. And the role of non-alignment within the UNCTAD and later on rules that were taken over in the WHO cannot be overemphasized. For instance, as we know, the special and differential treatment provisions, for instance, that you currently find in the WHO rules evolve as a push by non-aligned movement or non-aligned countries. So this is very important to understand why I'm talking about that today. Well, the ongoing war in Ukraine actually has shown, at least from that perspective, that the interest of developed countries and developing countries do not align. So, yeah, for lack of a better word, they don't align in the sense that some feel that the battle is not theirs, that they have more other battles to fight rather than joining the race of imposing sanctions. So this is why the call may sound, the call for a revival of non-alignment may sound correct, or at least may sound in the place today. So the rationale behind being non-aligned in the current scenario stems from the very fact that, while sanctions are being imposed by US, other developed countries, these are third countries. These are not the countries directly suffering from alleged or I would say perceived or actual wrongdoings of Russia. It means that it's not Ukraine itself, which is the target of the actions of Russian action, which is imposing sanctions, but rather third countries. And in this battle, some countries feel, well, some developing countries or non-countries on the global south feel that there may be reasons, there may be avenues to solve the matter beyond what has been imposed, or at least been suggested by countries that have the means to impose the sanctions. And this is also have to do with who has the means to impose the sanctions. And in this battle, some countries don't have those means, and they feel that the battle is not theirs. They are better fought by others that have the means to fight battles. And again, the fact that some of these sanctions are unilateral in their nature may justify their reticence to join the battle. They are unilateral because, again, they are not concerted. And again, they are not imposed by the ones that are suffering from the direct actions of Russia, but by third countries. So this in itself raises the question of who is entitled to join the battle and why some countries might feel that they don't want to be involved in this concert of sanctions. So, so this is why the international law is now being, or international relations or international affairs are being polarized in that sense, that some countries feel that they are not, that they reject, right, the use of, by Western powers, of unilateral corrective measures. Because again, this is not the first time some countries of that magnitude are using sanctions against UK countries. So the simple fact of having these sanctions today reminds some of these countries of the fate they have suffered in the past, which means that they may not be willing to align with with the current music which is being played at the global affair. Well, is there any value in neutrality? I asked myself and asked in the paper. This is where the argument between the devil and the deep blue sea actually comes in. Well, I would continue with two quotes, yeah, if you prefer, one quote. One quote, the first quote is from Desmond Tutu, who says that if an elephant has its foot on the tail of a mouse and you say that you are neutral, the mouse will not appreciate your neutrality. So he says so, and this is the premise of that quote, is that you are faced, I would interpret that by the supposition that there are two unequal parties. One is an elephant and the one is the mouse here. But what happens if there are bystanders, innocent bystanders? Well, this is an African proverb that says, when elephants fight, it is the grass that suffers. When elephants fight, it is the grass that suffers. Meaning that sometimes you might be an innocent bystander and suffer from the consequences of the war. So this is why I question the value in neutrality. Is there any value to remain neutral from this perspective? Which also means that, so maybe the non-alignment movement might have to have their own course, might drive their own course of action without necessarily being neutral to what's happening in the global affairs. Again, in the context of sanctions imposed against Russia. So this is why the paper actually is striving towards, by asking itself whether, is there any lesson that non-alignment can learn from the current situations? Yes, there are lessons that they can learn, but should they remain neutral? This is also questionable in the sense that there may be bystanders suffering from the grass, so as a grass suffering from the elephants that are fighting in the room. So meaning they might also have to devise their own rules, which actually adapt to the current situation in global affairs.
Great, wonderful, thank you very much. So we have about 6 minutes for questions. And I want to say that these papers are an early stage, and I haven't talked to the authors about this, but I think they would also appreciate provocations or reactions that do not end in a question mark, as long as they are polite and short. Okay, yes.
So I have a number of questions. First, I'll start with the first speaker. I'm sorry, I was a bit late, but Regis, I have heard your comments. So basically what you're talking in your presentation, you're talking about this developing country divide on the legality of the This debate has been already there for quite some more time, at least since 60s. So, but then you also, I have heard you talking about that these sanctions that are mainstreamed by the US against Russia, it's some sort of a Cold War philosophy. And in this respect, I would like to ask you a question. Since 2014, there were no sanctions against Russia. Actually, the sanctions were introduced in response to certain actions, in particular annexation of Crimea. And then, again, I don't think that anyone would disagree. They were very hard introduced sanctions. That were not stringent sanctions that we have seen after 24th of February. And also in this respect, when we're talking about, this debate is always about perpetrator and the victim. Those countries that impose sanctions, that violators of international law, and then there are countries who are kind of suffering from these things. Then I would like to draw attention to the work, for example, of Ventouratou, who's Russian author who wrote a big piece in Pennsylvania Journal of International Law, who actually analyzes practice, arguments found by Russian scholars and practice of Russia using economic coercion against neighboring countries. So I think this debate is much more complex than just perpetrating the victim. So I would like your reflections on this one. I have questions.
Okay, let's take one more.
To Armin.
Yeah.
Sorry. You're talking about financial sanctions, and your definition is mostly like it's sanctions that are against countries, but there are really narrow target sanctions which target particular individuals and particular companies. And then we focused, when we were discussing the legality of financial sanctions, we focused on secondary sanctions and their violation of jurisdictional laws or principles of establishing jurisdiction. This is kind of, there's no question here. The question that I have, what we are talking about primary sanctions, what if Canada, for example, sanctions certain companies or individuals, not secondary sanctions, but sanctions inside of the country. These are per se illegal, based on what grounds they are illegal, do they per se illegal, what is wrong? And the last question.
Well, let's just, I want to find one. Yeah, sorry. Yeah.
While in the piano, you have set out very interesting policy prescription. You have not entered into the question of international legality. Maybe that's more for Anna.
Yeah.
On your scope, but interesting questions arise there for the legality and origin. You know, it's no question that the product made of steel or the finished product is not of Russian origin just because the steel is Russian. No matter how you manipulate your rules of origin, the true origin is not Russian. Mm-hmm. The second point, Article 20D is something that belongs on the map when it's about circumvention, but it isn't always. And therefore, the question is whether you can use Article 21 for restricting trade through a completely uninvolved destination, just because there is onward trade or processing and further and lastly, there are also these further export restrictions which are imposed by the first exporting country. That raises the question of extraterritoriality and is the effects of the Anna, you have.
I just want to click from up here. Yeah.
Yeah, thank you very much. It's a very interesting panel, but I would like to ask my question to Diana, because she was giving an explanation of the rules of origin. And I would like to raise the issue with the customs union. There's a customs union between Turkey and European Union. Now, Turkey typically does not apply sanctions to Russia. In fact, our trade volume with Russia expanded exponentially over the last year. Now, I'm importing a product from Russian Federation, and since we have a customs union, there are no customs checks at the border, and rules of origin are not applicable. So what do you suggest in those circumstances for the European Union to actually check that those products which are imported from Russia via Turkey using the customs union can be effectively neutralized?
One more. Oh, yeah.
So every time I hear the word compensation, I'm sorry, confiscation, I'm traders. So just a question, like I'm not expecting an answer. It's what would you do with investment treaties in this case? Yes, you can play with Article 20, 21, and when it comes to trade, and most of the discussion has been about trade. But what happened in a hypothetical situation where the countries impose sanctions against Russia, freezing and confiscation and all that stuff? Then you have Russian investors bringing claims against those countries. They are not Ukraine. They are Germany, they're Switzerland, Canada, and all the treaties that they have with Russia, they have zero exception, zero. So what would be the case for these countries? Just ask. Yes, hypothetical.
I think time is up, so let me just make a marker. I disagree with your interpretation of 20A. So let's have a bilateral on this.
Of course.
Just for the audience.
For the protocol. On the record. Okay. One sentence from every panelist, and then we've got to cut it off. So let's start with Regis, and then we'll go down the line. So final thought.
Well, I'm not sure I got all the questions right, but I would simply say that some of the sanctions, I mean, I heard about Crimea, but there were sanctions that were imposed on Russia when it invaded Crimea. But of course, it didn't make the same international echo like the ones that we're actually listening to now, because again, it never went to the same, it never escalated the same at the same level. Well, Russia is a partner for many global South countries, and they don't want to simply sever the ties, the tie that they have with Russia, just because, again, there may be some narrative around. Of course, they may not be. This is not personal opinion, but there are narratives around what is happening in Ukraine. There are also international justifications for what is happening in Ukraine, not only by Russia, but also by Ukraine. So what some countries are asking is to use international law itself to solve the matter, simply because, again, international law allows that for happening. To solve it, there are disputes that can arise. There are also collective measures that can be taken, but again, there needs to be a unanimity, or there needs to be a sense of collective action that is driving to solve the matter. So basically, what I would simply say in this regard is that meanwhile, sanctions are there to impose or to induce compliance with certain norms. At least there are perceptions that they may not always be just. So, which is why some countries remain silent or at least neutral in the wake of these international sanctions against Russia.
One sentence, Daniel.
Yes. Difficult to summarize.
Yes.
So I think that the question, especially the one on investment, prompts us, I think, to what I think is the main problem here, is the lack of legal sophistication on the justification provided by states. It's mostly a feeling that I had while looking at the sanctions that are taken, and then we're trying to think how we fit. I think if we had a better picture, we would probably be able to address these concerns. Countermeasure and investment treaties is an open question, right? Do they operate? I think we might see a revival of that debate going forward. It would help if states were a bit more overt as to what is the legal basis. I find it extremely frustrating to read the EU Commission website that says our sanctions are completely compliant with international legal obligations. That's it. That's one line, and doesn't help me. But I think it's the beginning of it.
But in the guidelines, they do say some of them might be inconsistent with WTO rules, right? Some are under the exception, some may not.
I choose the shortest answer, Irina. Let's do it bilaterally after the session. I'm not 100% sure what kind of primary sanctions you have in mind. In general, regarding jurisdiction, the established principles should then apply, territoriality, effect doctrine, etc. Regarding IMF, I would not distinguish between primary and secondary sanctions. The regime does not, the IMF regime does not know this distinction between these categories of sanctions.
Well, sure, we will disagree later. I just want to add just an extra comment here, which is, sure, maybe we could reinterpret Article 20 to fit this kind of considerations. But there's an issue of desirability and practicality that we should also consider. And I think that this is demonstrated a lot in the case of Saudi Arabia intellectual property rights, for example. Saudi Arabia comes out and says, Qatar finances terrorism, right? Maybe they do, maybe they don't. No one knows. So we don't really know whether the prior international wrongful act has actually taken place. And we can't know it if we also invoke public morals instead of the security exception. But if we do countermeasures, then we add some extra requirements under customary international law, which may be able to kind of put this kind of exceptions into like a narrower box, because perhaps we tend a little bit to over squeeze far too many things into these exceptions. And yes, I meant to Rodrigo, of course, not all circumstances are the same, but countermeasures, but also necessity, self-defense, and some exceptions exist. So some kind of restrictions on investors could also be accommodated under the general defense, right? Should not forget about general international law.
No.
So the legality question is one we go into in some detail in paper, but we were happy to leave the Article 21 discussion to others. Lastly, one of our conclusions is that the level of compliance with sanctions has to be clear to business, and there should be a clear distinction between a good transaction and one that should raise a flag. Because you don't want a situation where there's an importer in Armenia who requires some dual-use good for a legitimate purpose, but EU exporters aren't willing to carry it out because it's too much hassle for them. So I'll leave it there.
I guess we would say, when faced with something new, look into your legal toolbox and see what you have, and use those tools to assist you in preventing circumvention of sanctions or whatever your political or geopolitical scope and goal is. So that would be our conclusion.
Wonderful. Thanks to our panel. Thanks for this.
And the project group received the 507.
507.
I look forward to reading about this bomb.
I wish we had more time. So
Classic PIL lawyer coming into the VTO, trying to rip things up.
yeah.
That's great. Yeah. Sorry, I set you up as if you didn't talk about the law. Of course you did.
No, it's okay, but it's on lucky.
Right.